Okay, this is case 2161344, the people of the state of Michigan versus David Kennedy. Mr. Kennedy is charged with 1 count of weapons carrying concealed set for preliminary examination. State appearances.
Good afternoon. Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Your Honor, may I please this honorable court, Larry Polk on behalf of David Kennedy, who stands for my immediate right. Mr. Kennedy, state your name for the record.
David J. Kennedy.
Good morning.
Morning.
Is it correct your client is going to exam today?
That is correct, Judge, and I just, on record, asked the prosecutor if they're ready to proceed with their witnesses.
Yes, Your Honor. Our witnesses are here and we're ready to proceed.
Any objection to the waiver?
No objection.
Okay, Mr. Kennedy, I'm going to ask you a series of questions. If you don't understand my questions or if you can't hear me, let me know, okay? And make sure you speak up or
Okay.
respond.
Oh, I thought that's what you were gonna do.
Oh, no, I'm not going
I'll just do this, Judge.
I swear, you raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Okay.
Yes.
Mr. Kennedy, is it your wish to waive your preliminary exam today?
Yes.
Make sure you speak up, okay?
Yes.
You understand you have a right to a preliminary exam?
Yes.
And if we're to demand a hold today, people would have to show at the probable cause standard, which is the lower standard in criminal law, it's still a standard, that the one charge I read off was committed in the city of Detroit and they should probably commit that crime. You understand that?
Yes.
And then by waiving your exam today, people do not have to show any evidence. You
Yes.
understand that?
Yes.
And knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you mount over to Frank Murphy Hall of Justice, Third Circuit Court, for a ring on the information. It will be April 10th. It will typically be 2 weeks from today, but the court's closed on April 7th, so the next day, business day will be April 10th, 9 o'clock.
Okay. Here you go.
Thank you.
This one. Oh, how about the date that,
You are ready.
okay, 2355566, people of the state of Michigan versus Richard Aubrey Morlett. This Morlett is charged with count 1, robbery armed, serious injury, count 2, assault with intent to do great bodily harm, less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault with individual finger force, offense notice set for a preliminary examination.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Your Honor, may I please this honorable court, Larry Polk on behalf of Richard Morlett, who is present, stands to my immediate right. Mr. Morlett, state your name for the record.
Richard Aubrey Marlette.
Morning.
Good morning.
Okay, any preliminary matters?
We ask that there be a mutual right of sequestration as it relates to any witnesses in this matter.
No objection. Okay, any officer charged anticipate on this case?
They're not in, they're not in the courtroom right now, Your Honor, therefore, I do not believe we'll need them to testify, but no officers are in charge here. And, or at least not seated in the courtroom.
I'm just seeing if you may need to call or an officer charged, in charge on the way or may testify situation.
Not for
Okay.
preliminary exam matters, Your Honor.
Okay, all right,
Thank
so
you.
if there's anyone on YouTube who is watching, who may be a witness on this case, now is your time to log off, and for the record, in the courtroom, the only parties present are the staff, the attorney, and Mr. Moore-Lett. So thank you, first. And then people call Mr. Diallo Alexander.
Restaurant.
Had some weed.
Anything else? You made a statement to the police, right?
Yeah,
And everything you put in that statement was true, right?
yeah.
Did you tell the police that you were, there to bring in some cocaine?
No, I did.
Okay, did you tell the police you sold cocaine?
I told him it was about some drugs. I was bringing some drugs.
My question to you, or you were bringing them some drugs? And so it's your testimony that the drugs are for the weed,
Yeah,
but not cocaine?
yeah.
Okay. Did you tell the officers when they took your statement that you sold cocaine?
No, I did.
Okay. Were you on any type of narcotics on the day of this incident?
Yes, I was.
Okay, what were you on, sir?
Ecstasy, weed, and cocaine.
Do you know if any of that affects your memory or your ability, to think?
No, it doesn't.
Okay, so you don't believe that cocaine, weed, and alcohol together would, alter your thought process? So it's your testimony that Mr. Morlet called you.
Yes.
Police have your phone?
I just got my phone back.
Okay, so they took it.
They took my phone from me.
Okay. Were there any, text messages in that phone from Mr. Morlet?
It was a phone call. They made me unlock my phone and they deleted the phone call off my phone.
Phone call. With no text message.
No text message.
Okay. Did you tell the police that you were made to unlock your phone?
Yes, I did.
You did?
Yes, I did.
So when you gave your statement to the police, you told them,
Yes, I did.
okay, now you had an opportunity to review the statement you gave the police.
It was later on I was able to tell them that. It was a couple of days later, after I got out of the hospital, I was able to tell them that.
So you went back to the police and made another statement?
Yes. I told them, well,
Listen to my question.
yes, I did.
You made a statement initially, correct? At the hospital? Yes?
Yes, I did.
Okay, and then you're saying after you got out of the hospital, then you went back to the police and made another statement?
Yes, I did.
Where did you go to make that second statement?
I went to the precinct.
Okay, did you write?
No,
Did you write
I was
anything?
talking to the police. The officer in charge.
Okay, did you sign anything?
No, I did.
You didn't sign anything, you just talked to the
Either
officer.
time I did.
Let me ask you the question, and then you can answer so that the court reporter doesn't get us mumbled together. So let me finish the question, okay? So you were talking to the officer in charge, correct?
Yeah,
Okay, and that was, do you know what day specifically that was?
it had to be the 16th or the 17th, I'm not sure. I didn't have a record of that day.
16/17, and you talked to the OIC. Did you see the OIC here today? And my question is not, do you see the OIC? Did you see?
Excuse me, what is the OIC?
Officer in charge.
Well, I don't see him here today.
Okay, because that's who you spoke to. And you didn't see him out in the hallway.
Yeah, I seen him today
Okay.
in the hallway.
Okay,
He's
so,
not in the court.
okay, but you did see him today.
Yeah,
You know his name?
yes, I do.
What is it?
Okay. Call it. I can't recall his name right now.
So how long did you, how long were you at the location? About
At least an hour and a half, a little more long. Yeah.
an hour and a half. Now, in your phone, have you ever text between yourself and Mr. Morlet?
I have to text. What do they got to do?
Don't worry about it, just answer my question, sir.
Yeah, I've texted Rick before.
Okay. Have you ever been convicted of a felony for theft or dishonesty?
No, I haven't.
Let me finish the question for you. In the last 10 years.
No, I haven't.
So you stated your phone was returned to you. Correct?
I'm police.
Phone was returned to you, sir?
I'm the
I'm
police.
not asking you who gave it to you, I'm asking you a specific question.
You asked me a question, I
Excuse
answered.
me, I'm asking you a specific question, was your phone returned?
Yes,
That's
it
a yes
was.
or no? Okay, thank you. Anything else returned to you, sir?
No,
How many times do you believe you were hit during this incident?
over 50 times.
Over 50? What about over 100?
Seems like over
I
100.
don't wanna know what it seems like, I don't wanna know specifically.
I wasn't able to count the blows, blow by blow. I wasn't able to keep track of the blows.
So did you tell the police that you were hit over 100 times?
I said, I told them, it's hit over 80 times,
Oh, you talking about 80?
about 80 times. That's what I told them.
How long have you known Mr. Morlet?
I've known him for about 3 years.
Out of that 3 years, you've been friends.
We were friends, we was okay, we was talk, we passed to each other in the community, we were friends, we was okay.
So what would possess you to go to his house at 3 a.m. in the morning?
I believe that, I went over everybody else.
Okay. But I'm specifically asking you about what possessed you to go to Mr. Morlet's house at 3 a.m. in the morning.
Take some weed and some ecstasy.
Oh, so you were taking ecstasy over there?
It was my personal ecstasy.
Okay. Did you tell the police that you were there to take ecstasy over to Mr. Morlet?
They didn't ask me that. They didn't ask me when I was taken over there.
Did you tell the police that, Mr. Morlet was trying to purchase $20 worth of cocaine from you?
I didn't have no cocaine.
Okay. So you didn't tell the police?
No, I didn't.
Now, when you made the statement to the police, did you get a chance to review it?
No, I didn't.
So,
I was in the hospital then.
okay. So you made the statement to the police. Did they tell you that it was being videotaped?
No, they didn't.
Did you see the officers with body cams on?
I couldn't, I didn't, when they were sitting down, I couldn't see what they had on.
So you didn't review your statement, but the information you provided was truthful information, right? And when you went to speak to the officer in charge after you were released from the hospital, you talked about the case, correct?
No, I didn't. So, can you repeat that? Because I'm not understanding what you just said. You sort of confused.
I'm not trying to confuse you, sir. I'm just trying to give you information that you might have. And so my question was, after you were released from the hospital, you went to the precinct where you talked to the officer in charge, correct?
You're right.
And you talked to him about the case, correct?
Yes, I did.
And did you go over the statements that you had made to the officers that came to the hospital?
No, I did. I talked to him about the reason why Mr. Morley did this. It was over a woman.
Okay, and you told, did you tell the officers earlier that this was over a woman?
No, I didn't.
Okay,
They
so
didn't ask me.
they didn't ask you that, but they absolutely asked you, was there a reason that this happened? If you and them were friends,
They
and
didn't
never
ask
had,
me
and
a
never had any disputes. When I finish here, you can.
Ms. Alabama? Make sure cross-examination typically leads to an argument. Like, the prosecutor is gonna have an opportunity to follow up and verify anything that you've been able to answer. So if it's yes or no questions, answer yes or no, and the prosecutor can follow up and flush out anything that you feel is wrong, okay? Understood?
So when the officers came to the hospital, you did not tell them this was your belief that this was about some female. But when you went to speak to the officer in charge after your release from the hospital, you told him that this was about some female.
Yes, I had talked to some people. I talked to some people on the streets. Female friend,
What's her name?
just,
Jessica what?
I don't know the answer.
Is that what she did?
Judge Natter, what's the relevance of this?
Judge,
The
he's
name,
saying,
the name is relevant, whether he knows or he's trying to understand basically if this is the truth or not, I understand. But where she lives, I don't know if that needs to go on record.
well, I don't know, I'm not asking for the specific address, but he just
Whether
gave the
she-
street, so I can begin to do some investigation in terms of who she is.
I'd like to put on the record as well is that his indication of this woman thus far, as he indicated, was told to him on the streets from people, which would be hearsay. So that's why I hate to go down this long line because everything he's gonna say is hearsay, and I would object to, because he's telling us what other people told him after the fact.
But I'm not asking him in terms of the substance of what was told to him. I'm asking him, he says that this dispute was about Jessica. So I'm trying to find out who is Jessica. She doesn't have a last name. I need to know what street she lives on.
I don't know what she is. I don't know what she is.
Would Jessica, information about Jessica be in your phone?
No, it's not.
So you talked to some individuals on the street and they gave you some information about Jessica?
Some other girl that's supposed to told Rick what happened.
I'm not
This,
asking
you know,
Objection, Your
I'm
Honor.
not asking about what somebody else supposedly told anybody. I'm asking you specifically, you talked to some individuals, they provided you with some information about why this incident happened. Is that correct?
yeah,
Okay. What is the name of those individuals that you talked
I don't know them by now.
to? You don't know them by name. They come up to you and provide you with the information, did you go to them?
Talk to them.
Did you seek them out or did they seek you out?
Mutual.
Say these are just some people that you don't know their names, but they provided you with information about this incident. You got a nickname for them? Or just some question?
Charles Mander, just want to clarify, you indicated to defense counsel that your phone was returned to you. Is this a phone? Is this one of the phones or the phone that you mentioned was actually taken?
There was 3 phones taken from
So the phone that you received back from the police was one of those phones that the defendant had taken from you?
yeah,
Or the defendant or the other person?
yes.
Okay, and, who gave you back that phone?
The officer,
The police officer? The police gave it back to you?
yeah,
Okay, and, when did they give this back to you?
this morning.
Pardon me?
This morning,
Okay, so you just got it back from the police,
yes.
okay. And, did they recover anything else that was taken on that day? Did they give you anything else more specific from that day?
I don't know what they took. I haven't seen none of the stuff they took. I know they, said they got my cut up clothes.
Objection,
my
judge is
jewelry.
hearsay.
Yep, response. I understand. Sir, if you could just tell us, what the police have actually, given back to you as opposed to, what they told you.
Cell phone.
Your cell phone is the only thing they've given back?
Yeah,
Okay. And you indicated to defense why, what you believe or what you heard, of the reasoning. But I want to clarify something based on what you had initially indicated. So did you know why the defendant, did you call him Rick, assaulted you with a wrench at the time he was actually assaulting you with a wrench?
no, I didn't.
Okay.
He told
Were
me.
you expecting that?
No, I wasn't.
Okay. And so you can't be sure, aside from what people that you don't even know their names, you don't even know, you can't be sure why this man decided to do that.
He told me to run everything.
Pardon me?
That meant he was robbing me at that time. That's what he told me.
Oh, who told you what?
Rick told me,
Rick told you what while he was robbing you?
run everything.
Pardon me?
Run everything, which means he was robbing.
Okay. So his reason, according to you, what he stated to you, that him attacking you is because he's robbing you. Is that what you're, is that be accurate what you just said to me?
Right.
Okay, I just want to clarify. All right. So. And then the defense asked you about your statement. You indicated that this statement was at the hospital. So would you say that today, is your head a little bit more clear than it was the day that you gave that?
They just woke me up, and I was out of morphine. So when they was questioning me, I really didn't understand what they was talking about. So I was
But
just,
today, the statements you're making today,
yeah,
are they truthful to the best of your knowledge?
yes, they are.
Okay. No further questions? Thank
Step down. That's in the hallway. Any other witnesses for the people?
you. No, Your Honor.
None on behalf of defense judge.
So as Ms. Alexander leaves, you may begin, right?
I'm sorry, I couldn't hear you, Your Honor.
You can begin with argument after Mr. Alexander steps out.
Your Honor, the people move that defendant Richard Marlette be bound over on count 1, robbery, armed, serious injury. Count 2, assault with intent to do great bodily harm, less than murder or strangulation. Count 3, assault with a dangerous weapon, felonious assault, and we reserve argument for thank you. Attorney Volk.
Judge, I'm gonna object to the bind over and I leave it to the question discussion as it relates to the bind over.
Thank you. Your Honor, people feel that by probable cause standards, the probable cause standards have been met based on the testimony of the victim, Alexander. He was on the date testified to on February 11th in the city of Detroit at the defendant's home, where he testified that the defendant assaulted him with not only a wrench, but also a knife, which would provide probable cause for count 3. The details went further, providing probable cause for count 2. The victim testified that the defendant hit him multiple times. He couldn't keep track, obviously. We wouldn't expect someone being attacked with a wrench over the head to count how many times he's being hit. But he did testify that it was multiple times, and with the wrench in his head. He also indicated that the defendant, and I'm narrowing it down to just the defendant. Obviously, there was another person that some testimony came out, but I'm focused on what the defendant did. And the defendant used a knife. By using that knife, he stabbed the victim, Mr. Alexander, and cut him on his face. These injuries that went on for, again, quite a while, he couldn't indicate if up to an hour. He wasn't sure, but these injuries ended up with him having staples in his head, cuts all over his face, a broken arm, his jawbone dislocated, stitches, and 4 days in the hospital. Yeah, 4 days. It wasn't just a trip to the hospital and they let him go. It was 4 days. This is beyond probable cause at this point that this resulted in great bodily harm. And obviously, if you're hitting someone with a wrench, cutting with a knife, you have intent to make sure that that's the result that happens. It is great bodily harm. While doing this, the defendant proceeded to rob the victim while hitting him with a wrench, both before and after the robbery. Uh, The victim indicated his wallet, his money, glasses, cell phones, jewelry, and anything that was in his pockets were taken. Specifically that he could have observed, he observed jewelry in his wallet and money that defendant actually took during this time. And we believe that would result in count one's probable cause being met. This is a particularly heinous type of crime in the fact that he didn't only assault this person that was, let's say, an acquaintance, at least somebody that you're friendly enough that he comes over at 3, 4 in the morning with some beer. And for whatever reason he went there, he did not deserve to be attacked with a wrench and a,
Beer and drugs,
huh?
beer and drugs.
Right, exactly. Yes, Your Honor, right? You're coming over there, you're high, or, I mean, it's not things that we want to have, victims or defendants doing, but this is what they're doing. They're partying and come over there and you get hit with a wrench and you get attacked. And regardless if the victim was high, regardless if the victim was there to bring his acquaintance to some drugs and some beer to get high with him, that does not excuse or give anyone reason to attack them or rob them. And attack them so severely as the victim indicated, he was bleeding from head to toe. And when I say particularly heinous, the defendant then goes and cuts his clothes off. So you have this victim running in the street, trying, as he indicated, basically just trying to save his own life, and he's bleeding from head to toe, and he runs over to someone else's house, and an ambulance comes. And then he passes out once the ambulance comes. I mean, probable cause, we believe, has been met on all these counts, and move that the defendant be bound over on all 3. Thank you.
I do believe people have met his burden of proof, the probable cause standard. People have to show the defendant used force for violence against Mr. Alexander. Second, the defendant did so while the person committed larceny. Here we have testimony that his money was taken, jewelry, cell phone, wallet, while at the defendant's house. Third, that Mr. Alexander was present in the course of the larceny. Fourth, that while the person committed larceny, possessed a weapon designed to be dangerous and capable of causing death or serious injury. In this case, we have a monkey wrench as well as a knife that Mr. Alexander was stabbed with several times. And for count 1, it also includes serious injury. I believe based on the testimony, Mr. Alexander was able to establish serious injury. He was unconscious when the ambulance took him to the hospital. He believed he had a broken arm, he had stitches under his eyes, staples in his head, his face. He was stabbed multiple times in the hospital for a day. And for count 2, assault with intent to do great bodily harm less than murder by strangulation. I don't have to recite again the injury and the assault that was elicited through testimony from Mr. Alexander, as well as count 3, which is one assault. I do believe there's maybe some questions about his forthcomingness for credibility, but not enough to not bind over based off of the standard here and the testimony that's provided. So with that, I will have Mr. Morlet bound over. Mr. Morlet, since you're in custody, it'll be 1 week from today, so it'll be March 31st at 9:00 p.m. for your arraignment on information at Franklin Foster. Anything else for on the record?
Nothing else, Judge.
Okay. Thank you. Thank you. Oh, Victim Advocate.
I was just gonna.
Always an attorney.
Good to see you.
You want some water?
Oh, no, I'm okay. I was just gonna have a chat real quick.
Oh, okay.
I appreciate it.
I just didn't want you to think I was neglecting you.
God, thank you.
I didn't think that was a little thing right
And those, DSU referrals, it's like a couple steps for those, so I said, I'm trying to get them all over so they can process them.
That's not everything. Sit down.
How you doing? No, man, you said wherever you want, so you could sit here, I can learn something.
Okay, yeah, Dr.
I'll see you off the man. Once I get out of here, it should be. Did you do the train? No, but it's,
Yeah, whatever, I do know, so.
yeah, we do know what we're doing.
Ready, Aliyah?
Right.
Water.
I just had to think for a second where I was at, Your Honor. Yeah, do you give me 30 seconds to run to the ladies' room? Absolutely. Thank you, Council, for giving me a moment. I apologize. Welcome back.
You know, things are better when you're here, so.
That's what I thought. That's what I thought. Why? It's cold out there. You know, he.
What y'all got there?
It might, if you want to sit down to
Oh, yeah.
another back. Okay, now, Mr. Jones. On the record, is the people of the state of Michigan versus Javante Jones, 2355056. Mr. Jones is charged with 1 count of weapons carrying concealed, set for preliminary examination today. Appearances.
Good morning, Your Honor. Good afternoon, Your Honor. Daniela Parrish on behalf of the people, P85495.
Judge, may I please respond to the court, Benson J. Tucson, 58609, on behalf of Devontae Jones, present, standing to my left.
Mr. Jones, please state your full name for the record, please.
All right. Devontae Jones.
Hello.
Here's my right, Judge, my bad. I'm always saying my left.
Okay. Any preliminary matters?
Seek restoration order, Your Honor, ready to proceed outside of that.
Okay. Anything from the people?
No, Your Honor, nothing from the people.
Okay, if there's anyone watching on YouTube who needs, or who may testify on this case, now is your time to log off. For the record, it's courtroom, it's only staff, attorney, and Mr. Jones present. Okay, Vice President.
Thank you, Your Honor. The people call Officer Nicholas Rocha.
Swear to tell the truth, the whole truth, and nothing but the truth. Ready? Okay. Doors in front here, and make sure you speak up in the microphone. And just for the record, prepared, I believe your officer charges is that. Well,
Your Honor, the officer in charge on this case will not be testifying today and likely not in the future.
any objection to the
No
officer?
objection.
Okay.
But I do have an objection for Officer Roach. He has all paperwork, he took it, but you can place it on the side, because I'm going to testify on the paperwork. Thank you. Thank you.
Next record, sir.
Officer, I was actually just about to say, if you could just speak into the mic, the mic is movable. If at any time you need to pull it up to you or even hold it on your person, you may do so. And if I ask any questions that you do not understand, please stop me. I'm happy to rephrase. And could you please restate your name for the record, sir?
Officer Nicholas Rocha,
Officer Rocha, where are you currently employed?
Detroit Police Department, 9th Precinct.
And what capacity?
I'm a police officer at the Special Operations Office in the 9th Precinct.
How long have you been a police officer, sir?
Coming up on 6 years.
Were you employed in this capacity with DPD on January 4th, 2023, sir?
Yes,
Were you by yourself or with a partner on that day?
I was with a partner,
What's your partner's name?
Officer Bailey Rumshaw.
Were you in full or modified uniform on that day, sir?
I was in a modified Class C uniform comprised of green pants, a black top, a black outer carrier with the words police on the front and the back, and a silver Detroit police badge on the left breast.
Do you have a fully operational body-worn camera on you on that day?
Yes,
Were you in a semi or fully marked scout car on that day, sir?
a semi-mark.
Were you or your partner driving that vehicle?
My partner was driving.
Did your duties as a police officer on that day take you at or near 17125 Walton Street in the city of Detroit, County of Wayne?
I believe it was Moraine and Nottingham.
You know how far away that is from Waltham Street?
I know.
Your Honor, I would like to amend the location on this to indicate Moraine Avenue, City of Detroit. And close to 17125 Waltham Street. Officer,
First, do you want to refresh his recollection as to what date he has to report, or do you want that to be the change information?
Your Honor, I believe, since the officer is indicating that, at least I believe he's indicating that that is not the correct address, I'd rather us just amend it on the record, but also.
If he can give us the address of where it actually occurred, if there is an area, or if he can give us the area where it occurred, because if it didn't occur on Walton, we don't know why Walton is on its place of things.
And that's why I was indicating just Moraine Street, or the area of Moraine or Crossroads with Moraine.
Well, that's what I'm saying, he may have some address in his report for actual information is different, or more accurate than just, right?
Your Honor, could we amend it to indicate Moraine and the area of Moraine and Nottingham Streets?
Okay.
Without objection. Moraine and Nottingham?
Yes, thank you. Officer, let me restate that question. Do your duties as a police officer take you at or near the area of Moraine and Nottingham Streets in the city of Detroit County, Wayne?
Yes,
Can you please tell us why you were near said location on that day?
I initiated a traffic stop on a silver grayish blue, more like a cobalt, Chevy Trailblazer.
Prior to initiating that stop, what were you doing around that area?
I was at the location of 11535 Moraine conducting a green light special attention.
Okay. So while near that location, please tell us what you observed that drew your attention.
I observed the Chevy Trailblazer at the location of 11535 Moraine. I ran the plate via lien, and per lien, the vehicle did not have insurance, and the registered owner of the vehicle had a suspended license or not a valid license.
At this time, though, you don't know who's actually driving the vehicle, correct?
Correct.
But this particular vehicle that you spotted did come back with no insurance?
Yes,
Okay, so based on this information that you obtained via lien, and you obtained it yourself, correct?
I did.
Okay. What did you do based on this information, sir?
Performed a traffic stop on the vehicle after it pulled out from 11535 Moraine.
Did this vehicle immediately pull over, sir?
Yes, I believe so.
Could you tell, prior to approaching the vehicle, how many occupants were in the vehicle?
I don't recall prior to the actual stop.
Okay. Once you stopped them, do you recall how many occupants were in there?
Yes,
How many?
2.
Where were they seated?
There was a driver and an individual by the name of Javante Jones in the front passenger seat.
Do you recall that you approached this vehicle?
Yes, I approached on the passenger side, the front passenger door.
And who approached the driver's side?
My partner, Officer Rumshaw, approached the driver.
once you and your partner approached the vehicle, did you observe any information, that the driver provided?
Well, subject us to the driver. My client's not a driver, and what's the information of the driver to do with my client?
Well, they pulled over the driver, so I want to make sure that we had a proper stop.
I don't know what the information
Right.
could be, or just, are we saying document, or are you saying?
Because we know now that my client is not the driver.
Right.
So we have an individual who, whether or not it's a proper stop, and I don't know if he would have, he possibly would have standing to contest the stop.
I can rephrase it.
I think it's important to know. Stop.
Yeah, I think so
I
too,
can
since he would have standing.
I can rephrase it. Did you, the course of your investigation, did you observe, whether the driver was indeed the registered owner of the vehicle?
I did.
And this is the registered owner of the vehicle that Lee came back as not having a license?
Yes.
Did you observe, what if anything happened with the driver based on this information?
My partner detained the driver for driving while suspended.
Suspended license?
Correct.
Since the driver was detained, what if anything, were you doing with the vehicle?
We planned on towing the vehicle.
So based on all this information, what interaction did you have with the passenger that was seated in the front seat?
I asked Mr. Jones to step out of the vehicle.
Could you identify, the person that you refer as Mr. Jones, if you saw them again today?
Yes,
Are they in the courtroom today?
yes,
Could you please tell the court where they are in the court and article of clothing that they're wearing?
yes. Mr. Jones is sitting over there wearing a purple hood and has his hair tied up.
Your Honor, may the record reflect the identification of Javante Jones, please?
Reflected.
Thank you. Did the defendant comply when you asked him to exit the vehicle?
Yes,
What, if anything, did you observe as the defendant exited the vehicle?
I observed the defendant had a cast on his left arm. I observed the defendant exit the vehicle. I observed that the defendant placed his left hand near his front waistband, which I did not seem to notice much because of his cast, because of his injury. What seemed odd to me was when the defendant exited the vehicle, he turned the front of his body away from me facing the vehicle, so his back was facing towards me, and then grabbed the same area where he grabbed his belt line with his left hand with his right hand, and didn't appear as he was gonna walk in a straight line going back to my car. It appeared as he was about to walk sideways, like a sidestep, and that appeared weird to me.
Based on your observations and experiences as a police officer for 7 years, well, what event did you do based on these observations?
To me, it appeared that the defendant might be hiding something from me, some contraband, and I patted down the area where his hands were going onto his belt line.
And when you patted the defendant down, what, if anything, did you feel?
I felt a magazine that was upside down and hanging by his belt. It was caught on his belt.
Had the defendant prior to that indicated to you that they were carrying a weapon?
No,
Did the defendant at any time indicate that he was a CPL holder and that he may have a weapon concealed? Prior to patting him down?
prior to patting him down, no.
Once you patted the defendant down and located a concealed weapon, what, if anything, did you use there?
I recovered the weapon, I recovered a tan Glock 9mm with an extended magazine. And I ran the defendant's CPO, which was suspended.
After you recovered the weapon, you indicated that it was loaded magazine,
Yes,
and then you indicated that you went to investigate the defendant's CPL status.
yes,
Did it indicate, when this, his CPL status was suspended or expired? Could you explain what that means? So he had a CPL prior to, but now this day?
correct. Per lien, his CPL was expired, or not expired, I'm sorry, was suspended in October of 2022.
Okay, so at least 3 months prior to.
Yes,
Okay. And you indicated it wasn't that it was expired, it was actually suspended.
correct.
Okay. Did once you determined that the defendant's CPL was suspended and he no longer had a CPL license, what if anything did you do?
I advised the driver on his civil infractions and driving with without a license because we were dealing with Mr. Jones. And I confiscated the firearm, placed Mr. Jones under arrest for carrying a concealed weapon, and I conveyed him to the Detroit Detention Center.
Was the weapon placed into evidence, sir?
Yes,
No further questions, thank you.
So you came upon my client being in the vehicle, he was the driver, am I correct?
correct,
And he didn't do anything wrong before you detained him.
correct,
So he was on the passenger side of the vehicle, outside of the vehicle. Had you already called for a tow truck?
no,
And did you question my client prior to searching?
I don't believe I did, no.
And you indicated that even though he's at the scene, he wasn't free to leave, was he?
I'm sorry?
Was he free to leave? Was Mr. Jones free to leave?
Oh, was he free? I'm sorry. After he got out of the car, he wasn't detained. It was just the observations I saw after that. Right? It was odd to
So
me.
did you tell him, could he leave?
No,
Did you tell him to stay?
I don't recall what I said.
And he still had not done nothing wrong, am I right?
Correct.
What type of pants did he have on?
I don't recall.
Did he have on pants?
I don't recall if they're pants or shorts.
He was wearing something, covering his underwear, am I correct?
Correct.
He had on a jacket?
I don't recall.
You indicated he had a cast, was his cast on his right, left hand?
Left.
Was his cast on his hand or going up his arm?
Going up his arm. It might have been covering his hand a little bit.
Did it reach up to his elbow, you know?
I don't recall.
Was his cast white or what color was it?
I don't recall the color.
And the lane that you ran on the driver, I mean, did you run the lane at that point in time before he pulled over?
On the driver,
Yes, on the vehicle, on the license,
on the license plate.
yes. Did you?
Yes,
was
the
it
license
run?
plate.
And when you observed the vehicle, was it parked, or was it running?
I believe it was running.
You're not certain?
I'm not certain.
Would you have been running lanes on, vehicles that were parked?
It would depend
Would depend on what?
if the license plate was visible to me.
But if a vehicle is parked and it's not running, having no insurance and the car is not running is not a problem, is it?
I can still run.
Unless it's being driven.
Correct.
You remember the name of the person who was driving the vehicle?
I don't.
Would it be in your report?
No.
Would it be in would it be in the other office?
I don't know if it's in his report.
Was his name not important?
It's not that it wasn't important.
Why would you have it?
His name was placed on our digital run sheet, but the report for the arrest was for Javante Jones.
But you indicated that you were to arrest the driver and take the vehicle, am I correct?
I never said I was going to arrest the driver.
But you were gonna take the vehicle.
Yes,
He was gonna be given a ticket.
probably.
Was he given a ticket?
I don't recall.
So you're indicating that my client standing with his back to you at the vehicle and his hands were down near his waist area, am I correct?
Yes,
No young people wear pants without belts, could he have been fumbling to pull his pants up if you know?
I don't recall.
You indicated that's what drew your attention, am I right?
It did.
Still had not done anything criminal, right?
To my knowledge, at that time, no, I just saw the gestures.
You didn't see any outline of a weapon, did you?
No,
Never saw an outline of a weapon, did you?
no.
How were you able to make notification? Well, let me ask you one other question. You indicated that, you were able to find out through lien that the CPL that he had initially was suspended.
Yes,
And how is, maybe I don't know, but how is that information garnered from lien?
there's a section in the program that I have a hotkey for on the computer. I set it to F7. When I hit F7, it has a prompt, which I enter my badge number in, and I can search it one of two ways. I can search it through the number on the card, or I can search it through the person's name and birthday. I don't recall which one I did.
Did you contact Officer Gunn? Sergeant Gunn? Did you yourself contact Sergeant Gunn?
Objection, Your Honor. I don't know who Sergeant Gunther is, and he lay upon me why this is being there.
Well, let me ask you, within the report, did you call any other police officers regarding my client?
I don't recall if I did.
Okay. And you indicated at some point in time he was walking, but walking kind of sideways. And where was he walking to?
I believe the front of my scout car.
Did you tell him to go over to the front of your scout car?
I don't recall if I told him to.
Or he on his own would have just started walking towards your scout car?
I don't recall if I asked him to walk towards my scout car, if I told him to walk towards my scout car. But where I was standing, he couldn't walk to the east because that was the door. He couldn't walk to the south because that would be walking into me. So or he couldn't walk to the north because that's where the car was. So the only path of travel was to the west.
And your scout car was to the west?
Yes,
And let me ask you, that was the area where you searched him at, by your scout car, right?
no,
Where did you search?
at the vehicle, at the trailblazer, after he's stepped out and did the gestures that I observed previously.
You indicated he did gestures, but he is that, and had you run his name?
I'm sorry?
Had you run his name prior
No,
when you were saying, did you receive any identification from Mr. Jones once he left the vehicle? Did you ask for identification?
I don't recall if I asked him for identification.
Do you remember him providing you with any identification, any license or any state identification?
I believe I just asked him his name and his date of birth, but I'm not certain if he gave me an ID or not.
When he gave you his name and date of birth, did you run his name through me at that point?
Yes,
So would you have returned to the vehicle? Or did you just, stay with him after he gave you that information? If you can remember.
I don't remember.
Okay. Mr. Roach, thank you. No further questions.
Just clarify, have you already patted, the defendant down prior to, checking Lee?
No, I checked lean on the defendant after I patted him down and recovered the weapon, not before.
And I apologize if I wasn't clear. I meant to ask, did you check Lee for the defendant, not the driver, the defendant, before or after patting him down?
After,
Okay. So you didn't know who, the defendant, was at the time,
correct,
or if he had a CPL?
correct.
So your pat down was based on the observations that he was making and relating everything you had described initially.
Man, I don't think he said lady.
Initially,
Term lady.
He
I'm
never
sorry?
said
He
lady.
didn't use the term lady.
Nope.
strike that, everything I said, as far as that, but your observations, however you had worded it, after that, is that the reason why you patted him down, or was there any additional reason?
No, it was just the gestures.
And
And one more question. He complied with you, am I correct?
Yes,
Yeah, he complied. No further questions. Thank you.
People move that defendant Javante Jones be found over on count one, weapons carrying concealed, reserve argument. Thank you.
Judge, I think that even at this point in time, the courts can make a determination whether or not this was valid. Stop, search, and seizure. I think at this point in time, Mr. Jones being a passenger of the vehicle, not committing any type of crime, and Officer Roach has indicated that he complied, that at some point in time, he made observations, but I asked Officer Roach, he ever saw, and now, you know, he was very forthright. He didn't see, like a lot of times you see officers saying that they see an L-shaped image in someone's pants, but Officer Rose at no point in time indicated that he saw anything that would present itself to be a weapon or present itself to be a danger to Officer Roach when he was dialoguing or communicating with my client. This was a unlawful seizure. I would indicate that there was nothing that Mr. Jones did on that day to get him to, and we see Mr. Jones has a weapon. I asked the officer about him having his hands close to his waist or his arms close to the waist area. Where are his arms going to be? Officer Roach did not know at what point in time what he was wearing at some point in time, and I know young people sometimes have pants that are hanging off their behind, and I don't know if he's trying to pull up his pants, but what we have here, I believe, and what this court has been able to hear is that this was an unlawful seizure. So I would request at this point in time, Your Honor, that this matter be dismissed based upon that unlawful search and seizure. Thank you.
I do agree with defense that our witness, Officer Rocha, was very forthcoming in the fact that, yes, the defendant was a passenger, but he was a passenger in a vehicle that was about to be towed away for no insurance and the driver having suspended license. He was asked to exit the vehicle, obviously, because of this, not because of anything he did. And it just so happened once he exited that his behavior at that point gave rise to reasonable suspicion for this experienced officer to have to pat him down. He indicated that he had a cast on that he used to cover his waist. Then he turned his body away from the officer and then used his other hand to also cover that area. That and also at the same time, as I said, turning his body away, trying to avoid the front of his body from the officer. This gave the officer reasonable suspicion to believe that the defendant was hiding something from the officer, and he opted to pat him down, at which time he felt an extended magazine with attached to a concealed weapon. He did verify the CPL status, which was not expired, but suspended. And did not want to ask because that information is not always necessarily proven, or sometimes it's in the middle of something. But there are reasons, as this court knows, that someone would have their CPL suspended. Again, it was not expired. It wasn't a whoops, I thought I had a CPL, and I didn't, and I'm carrying it. But even so, as a former CPL holder, he knows his duties. to let an officer know immediately, officer, I'm a CPL holder and I am carrying a concealed weapon on my person. And he was in a vehicle, and even in the vehicle, that is not proper transport, even having a CPL. So this is not a case of, whoops, I made a mistake, I thought I had to say, you know better when you are a CPL holder, you know what you have to do, you have to inform officers, whether you're the driver, the passenger, you have a concealed weapon on your person. But he did not do that, likely because he knew that he had had that suspended for whatever reason, whatever he did that got that CPL suspended. And that is why I believe, and probable cause, by probable cause standard, why he was moving away from the officer and trying not to have the officer see the weapon that he had, being barely held by his pants. At this time, I believe probable cause has been that defendant does not have a valid CPL. He had a concealed weapon on his person that had not only an extended magazine, but was loaded. And at this time, we believe that, again, probable cause standards have been met and asked to be found over on count one. Thank you.
And I would just indicate that Officer Roach didn't even say the car was going to be towed. We don't know whether or not the car was towed on that day of question, and or whether or not the driver received the citation. I think that Officer Roach was forthright, not knowing, and he indicated that he didn't really care about the driver. We found the weapon on the passenger, but like I indicated before, Your Honor, the officer saying these observations, but never said anything that proved to rise to the level of reasonable suspicion that was a weapon, or bring him out to frisk him for anything that was dangerous, or anything that would harm the officer. My client was compliant at all times, and I would indicate, Your Honor, this is just a bad search.
All right, just to clarify, I do believe that the officer indeed said, as when I asked him why he was having the defendant come out of the vehicle, indicating that the driver did not have a license or, excuse me, had a suspended license and registration, and did indicate that the vehicle was going to be towed. So
I do think customers that if the vehicle was gonna be towed, we don't know whether it was towed or not, or if it's
Correct.
exactly the driver received the citation.
exactly, and
That is, Your Honor.
correct, and I believe that, not to beat a dead horse, but everything else that occurred after the fact gave rise to reasonable suspicion, to have a pat down of the defendant, which again, that conveyed, the officer that he did have a concealed weapon. Thank you.
Okay, so, I will join in, so, I think Officer Roach is refreshing here at this courtroom. I've heard the term lady, dangerous neighborhood with high crime, seem nervous because his stomach was moving up and down because he's breathing. I am so tired of hearing the same terminology. That was actual testimony from someone who observed something very specific on this case. So I just want to get that off my chest. So, the question, I do think it's going to be a question of fact regarding whether or not the articulable facts here that are required for a frisk are enough as the beyond reasonable doubt standard. Officer Rocha testified that the defendant exhibited weird behavior, said that he first noticed the defendant with a cast on his arm, nothing alerted him at first, and that the defendant placed his hand on the waistband, and then the defendant began turning his body away, and Officer Rocha said that he might be hiding contraband, and saw the defendant walking in a direction that wasn't a straight line, as if he was hiding something. And that's when Officer Rocha had it at the belt area and felt a magazine, and then that led him to the actual weapon. The stop, based off of the lien search and having no insurance, I do believe was a legal stop. My opinion on the officers being able to use civil infractions and driving misdemeanors to, for other purposes, the different discussion. So I do think that the probable cause standard, people have met for approved, and the question of fact would be whether or not there was reasonable suspicion from Mr. Officer Roche's, from his point, to see whether or not it was enough to pat down the defendant. Since you were out of custody, Mr. Jones, your arraignment on the information will be 2 weeks, a little over 2 weeks from today. It would normally be April 7th, but the courts are closed, so it'll be April 10th at 9:00 a.m. at Frank Murphy Hall of Justice.
Yes, thank you very much.
Thank you. Anything else for the record?
Nothing for the record. I don't know if the prosecution has to be dismissed. So I'll give it that.
Thank goodness that was, and I was glad we did that.